specifically say that the trial court erred in not sentencing on those. In Noel, the Supreme Court ordered the trial court to make a determination, and I quote, whether the remaining non-murder felonies merge as a matter of fact into the felony murder conviction, and that's why the case was remanded back. And interestingly, in the Noel case, the Hewlett case is cited, 296 Georgia 49. That's a 2014 Georgia Supreme Court case. Same issue as before about the felony murders being vacated by operation of law. And then but in Hewlett, it was a malice murder case as well. But it gave some instruction, and I suppose that's why the Noel court relied on Hewlett, gave some instruction about whether there would in fact be merger. And in Hewlett, the important distinction was whether the felony that then led to felony murder was followed almost immediately by the death of another. So the question was whether there was a, quote, deliberate interval between the offense and the death. For those reasons, Your Honor, I asked the court to find, as a matter of fact, that those felonies do merge and that there is no reason and no statutory obligation for the court to sentence on the other remaining felonies that the state wishes to proceed on.
So I understand what you're saying. What you're saying is there's no deliberate interval then, because there are other cases.
Yes, I just realized that I put that. Yes, that's exactly what I'm saying, Your Honor, that all of this took place in a continuing manner, that there was no stop and start between the beginning of the chase, we'll call it, and the end, which led to the tragic death. So for that reason, I think that it can be distinguished from some of the other cases that Ms. Dunikoski may be relying on. It certainly stands for the proposition that simply because the felony murders are vacated by operation of law does not mean that the underlying felonies have to be sentenced upon. They don't still exist. They aren't still there. There still is a question of merger by operation of fact.
Okay,
all right? So, between the two statutory sentencing options that are before this court, the state is asking for the sentence of life without the possibility of parole. And they made that position known back in September of 2020, specifically September 16th of 2020, when they filed a notice of the state's intention to introduce evidence in aggravation of punishment. And in that notice, Your Honor, under the final box that's checked, the state indicated that it intended to seek life without the possibility of parole by relying upon three statutory code sections: 1651, which is simply the murder statute; 1710-2, which is the statute of criminal procedure that provides for what we're doing here today, the presentation of evidence in support of any sentence that each party is seeking. And finally, 1710-6.1 is the third code section on which the state relied in seeking life without the possibility of parole. And in that code section, that is, as the court knows, sets forth the inability for any individual who is incarcerated for the first time on on a violent felony, which results in a sentence of life with the possibility of parole, to not